is Peggy Clary of Clary Law Offices, and again doing our daily video chat on estate planning topics. And tonight's topic is a commonly asked question on who can serve as your personal representative under your will. And a lot of people are used to the term executor, but a personal representative is a person under a last will and testament who you specifically nominate, and you state that you want them to be in charge of your estate when you die, and they are the person that carries out all of the directions under the will, notifies estate creditors, and also makes sure all your assets are fully distributed in accordance with the terms of the will. Now, Florida law has different requirements when you serve as a personal representative. One, your relation to the decedent matters. So you either can be related to decedent by blood or marriage. So a cousin who lives in Ohio or their spouse could qualify to serve as the personal representative. In the alternative, if they're not related to you by blood or marriage, then also you can have a person who's a resident of the state of Florida serve. And we commonly give the example of your college roommate that lives in Florida that you get together with socially throughout the year. They're fine to serve. The same college roommate who lives in Maine, even though you see more frequently, they would not be qualified because their domicile is out of state of Florida. So a couple things that evolved from this question that oftentimes people struggle with when I consult with them is, I really want person X to be in charge of my affairs when I die, and they're not going to qualify because they are my college roommate who lives in Maine, but I trust them with all these important responsibilities. So Florida will not appoint them to be your personal representative. But there are ways around that, as they can serve as a trustee under the state of Florida. So maybe you decide to create a trust, and then the trust administration can be marshaled and led by this person you trust. And finally, the other issue that comes up is, what if my personal representative I nominate is unable to serve? Maybe they become ill or they've passed away. So Florida law says we look down the list to the next person you nominate, and if there's none, then there is a selection made by the majority of the heirs of the probate estate, and if that can't be fulfilled, we keep moving down the line, including the court having the ability to appoint someone. So there's lots of options when working with personal representatives, and I hope this video has been helpful to you as you're thinking about the person you trust to carry out your will directions. We hope you live a life of dignity, civility, and respect, and if we can help you plan at Clary Law, we stand ready to do that. Thanks again for your time.